Someone make it make sense.
I'll read a couple.
Hello, hello, squirrel friends of the world. How are you guys doing today? So we're back here with more trial coverage and pre-trial coverage of all the different cases. Another week. This morning we had the discovery hearing as scheduled from just the previous 2 weeks prior for Karen Reed. And I just actually refreshed the Idaho cases of interest page. There's still nothing else new out of Idaho for Kohberger. The last thing was that order regarding the Franks motion, which we covered. But while I'm on that topic, just briefly, I just wanted to touch on a couple things because I almost did a stream tonight on BK. And here's why, because I've been doing some more research since the last live stream from whenever, a couple days ago. And regarding the whole private road situation, regarding the case law. And I also wanted to go back and revisit some of these earlier documents or court filings from the beginning that relate to the IGG, because it's been such a long time and I think it could be helpful to review those. So, and then I also have pulled up the state's first motion for to be appointed counsel from the state attorney general's office. And so I've got a couple different things planned that I want to go over. Well, more than a couple, even without new court filings. So, so we'll see. I do have the next Casey Anthony episode scheduled for tomorrow. So we'll kind of see what happens. It may be that on Thursday night, I know it's Thanksgiving, but on Thursday night, I may end up doing the next stream for Brian Kohberger, so we can cover some of this stuff. And who knows, we might even have some more court filings before then. So anyway, what I want to do first is, in order to kind of recap what happened at the last hearing, because a lot happened. It was a really good hearing. I have this little video that I had put together of clips from me watching it live and EDB watching it live. And then of course, like Laura, and Runkle and Rob watching it, after the fact, but just sort of like us putting it together. It's not long, but it gives you a good overview of the previous hearing in case you missed it. And even if you did watch it, it's always good to refresh because there's so much going on in the different cases that most of us are all following. And also it's, it's got some funny moments as well. So let's take a look.
I think we can short circuit this, Your Honor. Our suggestion, I think it's a joint suggestion to the court, is that the sidebar conferences be unsealed solely for counsel at this point. Mr. Brennan's at somewhat of a handicap because, unlike the defense team, he was not present at sidebar. He does not know what the conference is.
This is interesting for a number of reasons. First of all, it's surprising they've got another motion that they're both agreeing on. Both parties are agreeing on. That's very unusual.
A lot more complimentary back and forth as well, right? They've already agreed on multiple things. They agree about the testing. They agree about some of the motions. They agree about this motion to continue. A lot more agreement and respect seemingly showed back and forth. We'll see if that goes away. But for now, that's a vibe I'm getting. It's a completely different vibe in the courtroom than it was with Lally, in my opinion.
It's interesting that the sidebars would be released to the public at some point, because that's so, I've never seen that in a criminal trial, potentially the sidebars. We could have the sidebars. Imagine that. I don't even want to get too excited, but it sounds like someday that will be happening.
So they're talking now about whether or not she is going to make the sidebars from the first trial available either to the public or to counsel, because right now they are sealed. The sidebar conversations should be public. So
StreamYard glitch.
I hope eventually they become public. Will it happen now? I don't know. But that's what they're arguing about when they talk about these sidebar conversations.
I hired an independent expert, and in the independent expert of the information, what he realized is that the information taken from the Informatics manual and the information taken from the Telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information regarding phones that were plugged into the radio, travel logs, things that are particularly relevant material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case.
Wow.
And so after he realized his oversight on the Gigabit, he filed a supplemental report.
Gigabate, Megateent. You guys remember that from W here. This is not surprising considering what we've seen with the law enforcement in this case, but also it's a big deal. What's really funny is I was shocked that no one else on LawTube made that joke, because he gets this Gigabyte thing wrong like a number of different times. And he got it wrong or got confused about it like a couple of times. And I was thinking the whole time, I'm like, oh my God, it's like Elaine. And finally, and so I was thinking it, but then finally after like the third time where he really gets it mixed up, I made that joke. And then I was like, oh, I bet, I'm sure EDB and Lawyer, and Rob, I expected other people to make that same connection. I was shocked that no one else did and disappointed, to be honest.
And what we learned is
we're going to get a lot of new information.
Not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader.
Oh my God.
Are we surprised? Raise your hand in the chat if you're surprised that the chips that were removed from the system were read with the wrong reader.
So that way the information was not available.
Wow.
Also, in the the infotainment system, there were actually 3 boards, not one. Only one was taken out. So I've spoken to the defense. I know they've hired an expert. I know they filed a motion.
While this isn't exactly the same, doesn't this remind you guys in some ways of Murdoch? I mean, not exactly the same. This is law enforcement fucking up, but still, it's like, oh, surprise, there's like all this other information, and it's the telemetry. It's the telemetry again. Amazing.
In the interest of justice, if they're able to get more information, let them get more information. We saw this very similar thing happen in Murdoch's case, where in the middle of trial, they were able to actually get the information. It's like, oh, I think it was GM or something. It's like, oh, they actually said you can provide it.
The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will...
Oh, not Trooper Paul, you say? Somebody else?
When it comes to Trooper Paul, I think that's a great thing for the state that it's out.
It's interesting. So he's hiring experts. So we can already see this is a huge difference, right? Because the Commonwealth relied on their in-house, if you will, law enforcement officers, such as Trooper Paul, Trooper Green, all these other people. And in other trials, sometimes you'll see the state hiring experts to do certain things, right? We saw that in Murdoch and others. So he's hiring. So what this means to me is the state is now spending way more money on this trial than they did on the first trial.
So even more money and resources from the state.
First of all, to bring this fellow in as a special prosecutor, step one. And now they're bringing in all these experts instead of using their law enforcement officers, which, they don't have to pay extra for them to come and testify. It's part of their job.
And now it's more money and more time to try this case a second time.
As much as I hate that there's a second trial, it will be interesting to see what accident reconstruction specialist would say in support of the state's theory, right? Because that seems like that's going to be tough. I'm really curious what that would look like.
The sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to, but they necessarily are in a full
look at Holly just sitting here like a toad on a log.
Pattern now.
Chips on and off of boards. It's a very technical procedure. It's very skilled.
No, this is really interesting because I'm just thinking back to the trial and in terms of with Trooper Paul and his utter disaster on the stand. But it started out with reading the telemetry data, which he seemed to not really know how to interpret. But there actually could be important information in this telemetry if you have all the data, which apparently they didn't, and if you have someone who can actually interpret it.
Yeah, and another thing that is a big time highlight of this hearing is Trooper Paul ain't going to be the expert, and this is an indictment on him, in my opinion, and the job that he did, and that alone is going to make this case go better for the Commonwealth round 2.
It'll just be really interesting to see what happens when you've got all of the information and you've got better experts or more experts on both sides in terms of what that will look like.
An extremely long resume, having done this kind of work.
I read it.
We're bringing him into speed in order to sort of engage it in some oversight and some observation. I don't have a principled objection to doing the retesting. What I have a problem with.
He took some shots at Trooper Paul there. He's like, what happened was they were looking at it, my expert and him, and he had no clue what he was doing. So he had to ask my expert how to do it. Now, I don't know whether that's true or not, but it sure makes sense after we listen to Trooper Paul testify, right?
I realized when I was trying to move and facilitate the testing of these chips in 2 weeks, and the government, the defense wanted more time. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it. I give it to the defense. And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so
Yeah,
it does delay the case.
no kidding, right? I mean, my God.
Wait a second. What did you just say?
Which I'm still in the process of doing, of reducing the witness list substantially.
Reducing the witness list substantially. Sir,
He said he's going to reduce the witness list substantially. That's a godsend, right?
well done, sir. Well done, sir.
So we have a lot less witnesses.
So it sounds like, now it'll be interesting to see how this pans out. It sounds like he's got a kind of a good attitude here, being fair, not playing hide the ball.
What I'm saying with that I like about him, and I like it a lot, and I will talk to any Massachusetts defense attorney about it. I like that he's planning on being an open book, turning things over in discovery, making sure there is no hide the ball. And that's what I hope for.
I appreciate the transparency. I think that's how it should be.
I was looking him up, actually. He's worked as a defense attorney as well. So he's being brought in as a special prosecutor, but it looks like most of his work is actually in defense. And that actually makes sense because he misspoke a few minutes ago and said something about when I hand something over to the government, right? And then he goes, I mean, the defense.
So I have a very positive outlook on Hank Brennan so far. And he, being a defense attorney, knows how important and how difficult it can be to get this discovery sometimes. So he is going to be an open book for the defense, so it seems.
Being overly forthcoming is how all prosecution offices should be. There should be no surprise. There should be an incredible amount of transparency.
But so far, he says he's going to turn over even more than what he has to in discovery. He's putting the defense on notice when he doesn't really legally have to.
So, that definitely changes things because you get a different type of respect going on there for the fairness.
Do you think it's beneficial for him because it's more likely to get rid of some of the fundamental fairness arguments that the defense may have, although they can still have some. But I like to see stuff like this. I will just tell you.
And it sounds like he doesn't want to waste time, slim down the witness list. So we'll see what the defense says in response. But I do like that he sounds like he's trying to be really transparent and forthcoming with the discovery and whatnot. So.
And I love that. Again, that's working like a private defense attorney.
One additional Rule 17 I'll have filed by Friday.
Oh, wow.
Similar to a number of.
File it and send notice immediately with the date.
Jesus Christ.
May I inquire, do I send notice on behalf of the Commonwealth or does the clerk's office send it?
The Mr. Lally can inform you on the process.
He doesn't-
Send it right out.
Again, he doesn't know because, like I said, I think he's typically a defense attorney, and it looks like he works both state and federal trials. But interesting that he's not quite sure of the steps here.
We will. Do I send notice on behalf of the Commonwealth or does the clerk's office send it?
The Mr. Lally can inform.
That's funny because he's, not an actual prosecutor. So it's like, how do I do this notice thing? And what does she say? Lally can tell you how to do it. If again, not a great look for Lally. It's like Lally can be your procedural person to help you show you how to file things.
You know how much I could not do what Adam Lally is doing right now? Like,
just sitting there while everyone is like
I can't do that.
quietly.
I cannot do that.
Meanwhile, Lolly just sat there the entire time like a toad on a log, literally like a potato.
He's just sitting there, not arguing, not saying a word. I hadn't said a word in court.
Okay.
Are we 9 a.m.?
Why don't we do 10 a.m., Jimmy?
10 a.m.
Get all the record holders who want to be here.
That's it. What?
Oh, well, I guess that feed just ended while they were still picking dates.
It just abruptly ends. I'll double check and see if there's another feed if this one cut off.
I'm going to go look and see if another feed has the rest of them picking dates. I hate it when the media does that. They're like, this isn't important. Actually, it is important.
Here's what we've got so far. We learned a lot. In summary, A, Lolly just sat like a toad on a log the whole time. B, we learned that there was a lot of information that didn't come in the first trial that was due to the government, or rather law enforcement, fucking up. So for example, like all this telemetry, it sounds like there's a whole host of other things that they didn't have because they didn't know how to do their jobs. And also, the Commonwealth has issued subpoenas for Verizon and other things concerning like cell data and cell phone records. So it looks like there's going to be more discovery there. And it's crazy to learn that there's just so much that was missing. Additionally, big news is that the state is bringing in a bunch of experts instead of relying on law enforcement to testify in lieu of experts, right? So they're going to be bringing in an accident reconstruction specialist, not someone hired by the state or who's already salaried by the state or the Commonwealth, but they're going to hire. So they're spending a lot more money. They're going to bring in extra experts. And he also said they're going to be winnowing down that witness list, consolidating it, no extraneous witnesses. This should be a very different trial.
This is very different than the first trial, where it's like, wait a second, we find out in the middle of trial, this witness was talking to this investigator and there's no report. And the judge won't even let him ask him about it. All sorts of unfair things would just pop up that the defense didn't know about. And if this prosecutor acts better than that, we shouldn't have that in trial number 2.
And again, like I said earlier, even though I hate that this is happening and she should have been acquitted, we should learn a lot more and have a lot more information. And, I looks like the Commonwealth is actually going to be putting on an illegitimate type of case. So it'll be interesting to see what they do with that.
I think it will be a shorter trial, a more efficient trial, and a more fair trial for everyone.
All right. So there's the recap from last time. So as of right now, guys, one thing that's interesting is that Judge Bev still has not ruled on whether or not she's going to grant that continuance, the joint motion for continuance from both sides, as to move the trial to April 1st, which is shocking. Like ever since that last hearing, I kept checking back, like, has she ruled? She hasn't. And as of the beginning of this hearing, if I said trial earlier, I apologize. At the beginning of this hearing, she still had not ruled on that. So we know that they're going to be talking about discovery. And in this case, it's interesting because a lot of times, we are hearing from the defense, right, in different cases where they're asking for discovery, like great example, again, Brian Kohberger, motions to compel, things of that nature. And in this case, it's the Commonwealth that is seeking to get in additional discovery that was not asked for in the first trial. So, for example, we have these different phone calls between Karen and her parents. We have Karen's different interviews with media outlets. And Lolly, the Lolly bird, didn't want to use any of that in the first trial. There he is. There he is in the flesh, in the feather, rather, I guess. And I think they're also going to briefly discuss a bit about the with the telemetry as well. So for this hearing, Mr. Alan Jackson is going to be attending through Zoom, which they had asked permission for ahead of time, of course. But let's go ahead and jump right on in, and it should have subtitles as well for you guys, although I don't know how helpful they are because they're usually completely off. And anyway, I will say Karen's hair looks great today. We'll start with the hearing.
It's 22-117, the Commonwealth versus Karen Reed.
Good morning, Your Honor. Hank Brennan, on behalf of the Commonwealth, along with me, Attorney Adam Lally, and also Attorney Laura Kohberger.
Good morning, Mr. Brennan. Good morning, Mr. Lally. Good morning, Ms. McAlberts.
Good morning, Your Honor. Elizabeth Little appearing on behalf of Defendant Karen Reed.
Good morning, Ms. Little.
And good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right.
Also, thank you. Mr. Jackson appears to be Zoom.
Okay, we can't see him though, Jim?
Yeah, we can't see you. Is that okay?
All right, good morning, Mr. Jackson. All right, we have several motions this morning. Let's start with motion for admission pro hac vice that you filed. And Mr. Unetti, I know these are freely granted, but I have a question about here. So you say good cause exists to grant this motion because Mr. Alessi has specialized skill and knowledge in representing defendants in matters of this nature. What do you mean?
Mr. Alessi is somebody with decades of experience in the courtroom, both on an appellate level and on a trial level. He has handled many criminal cases over his career. I have actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi. There are aspects of our defense that would greatly benefit from his expertise. I'd rather not go into the specifics in terms of the division of labor on our team, but I'd ask the court to, take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer who does some criminal work. I just don't understand what you mean by representing defendants in matters of this nature.
Of this criminal nature, he has represented criminal defendants throughout his career.
Okay, all right, thank you. All right, so let's go on to the discovery motions. We'll start with the requested records of Mr. Reed. I'll hear you, Mr. Brennan.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days for Janet Reed. The Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death. In a second-degree murder charge, there are a number of different theories that a Commonwealth could progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Miss Reed knew that she struck John O'Keefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Miss Reed knew she hit John O'Keefe when she did, the government's entitled to the full value of their proof. The records for 30 days begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She called both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew that she had left him behind. The 30-day period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there are no other calls in that 30-day period from Miss Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No. There were two search warrants from Miss Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies. The two search warrants from Miss Reed's phone are from a period of January 28th, 6 p.m. to January 29th at 6 p.m.
Okay.
And the other one is January 28th, 9:30 to January 29th, 5:30.
Okay.
And so they're not in Miss Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Miss Reed and her parents for 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other calls, it is terribly remarkable that she is panic calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impairment, but I expect the government is pursuing a witness, and my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life, then this is relevant material to show her knowledge that something dramatic had happened. And that's why I want the 30 days. Only phone calls with her mother and father, nothing else am I interested in. The second part is the 24-hour period with William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to that story that will be explored at trial. The time of the phone calls to Ms. Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, in your first discussions, my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it'll be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Ms. Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hang-ups don't register on a phone. And so they could be different. Secondly, I've learned that Ms. Reed's phone was sent to a taint team. And the Commonwealth does not and should not know what, if anything, was redacted from Ms. Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the benefit of the history. But what I do know is we cannot say that the records from Ms. Reed are a full accounting for records. And so that Mr. Reed's records stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor. Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his daughter. But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th, from not 1, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy, so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't
Right.
prohibit the Commonwealth from calling him.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at CF McCarthy's. and he wasn't present at the waterfall on January 29, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone, using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night. The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all four elements of Lampron were met. Here, the Commonwealth has failed to meet its burden to meet even a single prong of that four-part test. In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records.
So doesn't this
And I
have
would note, the Commonwealth's characterization of that interview is incorrect.
doesn't this have some overlap with BK as well? Oh, shout out to Iowa. Happy to see you. Doesn't this have some overlap there? Because, you know, think about like a lot of what we've been covering, right? With the motions to suppress, right? And, you know, these overbroad search warrants, right? Obviously this is not a search warrant, but there's a similarity here, right? In that they can't just ask for everything because it's a fishing expedition, right? So, you know, and unfortunately in Massachusetts, I almost said Idaho, in Massachusetts, you know, it's these filings aren't readily available. So I've not seen those available to the public in terms of, you know, what it is that they're asking for, but they describe it here in this hearing. And they're going to get into that more as we go along, but it's just funny how there's some overlap here with, you know, like a fishing expedition, you know, so to speak.
And incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning. The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed calls her father cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is spatially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron was also not addressed in the Commonwealth's affidavit. It's spatially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, "The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found." Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m., after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals.
Right, so this sounds like
appropriate use of Rule 17.
There you
This
go.
unsupported request is overbroad and must be denied.
There it is, overbroad. Yep.
Thank you.
Oh, Fluffy the possum. I didn't see that. Sorry, I didn't see that initially. Shout out to Fluffy the possum. Love it. We love Fluffy.
Very good. In between the multiple accusations of bad faith, what the attorney says that is most telling.
Oh boy. Oh boy.
is They don't know who answered the phone. That's a harbinger to trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't. And so we have to prepare that when Mr. Reed takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone, so there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature.
Fight it out on the
of
stand.
Uncertainty that the government is obligated to try to prevent that trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that. That is the exact point and reason why we need these records. Thank you.
All right, did you want to respond at all, Ms. Little?
Well, I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone. But all I'm saying is that neither do the Verizon records.
That's a good point.
There is no additional information the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but thank you. Ms. Little, is there anything specific to Mrs. Reed that you want to address?
Yes, Your Honor. Again, I just emphasize that the affidavit in support of their request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of land crime. That alone is a basis to deny the request, and it's not permissive. It's mandatory that the court deny the request. Land crime is very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay, thank you. All right, so we will move along now. Both of those are under advisement. We'll move along now to paper number 405, Commonwealth's renewed motion for all audio recordings, notes, emails, text messages, voicemails, and the possession of Gretchen Voss and or Metrocorp. I do have an opposition that I received this morning in an affidavit from Robert Birch, attorney Robert Birch, who I think is present in court. So Jim, did he file an appearance too?
Yes, previously.
And we'll use that in this case as well. All right, so Ms. Little, you did not intend to argue that, right?
No, Your Honor.
Okay, so Mr. Brennan, I'll hear you, and then Mr. Birch, I'll hear you.
Interesting, because so Gretchen Voss was the lady who interviewed Karen, and what's interesting is that, you know, this is a whole different situation because, you know, there's going to be an attorney who's here representing, I forget, we'll hear where it is, whatever media outlet she's with. But in other words, now we're involving another party, right, in this matter. So there's a whole other element to this. You could kind of compare it to like in Debt Be Heard with like the whole TMZ thing, and it was like pause everything, right? And then the TMZ attorneys came in, and you know they had their own little thing going on with that, trying to discuss, you know, I mean we've seen it probably in other trials. That was just the first one that comes to mind where you know you've got a media outlet like that, and they something is involved from that, and in this case, what it is that, the Commonwealth is going to basically make the argument that they want Gretchen Voss to be a witness and call her to the stand. So, and we'll talk about that more as we go along too. So.
The Commonwealth has filed a motion to reconsider in part, and in addition, there was a request for information that was not requested before by the Commonwealth. Your Honor made a ruling in the past to turn over portions of the materials, and in that ruling, it invited the Commonwealth after review to renew or reconsider the motion or the extent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity to review all of the pleadings relative to the Boston Magazine and Ms. Voss information.
Okay,
And
Boston
I've had
Magazine.
the benefit of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline, 2020, and Vanity Fair. And after a review of all those materials, it is clear that
I believe the Vanity Fair is the most recent one. And so that's really kind of what he's getting at here is that, you compare, I think part of this, I think part of this is he's kind of trying to help Lolly out a bit here as to why the Commonwealth, this is just where I see this going, why the Commonwealth didn't want to use these in the first trial, right? I think he's kind of referencing that they're over time because some of these are from 2020, others are from 2022, I think, and then the Vanity Fair one again was fairly recent. And I think he's trying to sort of say, well, the reason that we're asking for it now is because we're seeing these inconsistencies or whatever, almost as if to say, if it wasn't for this recent Vanity Fair one, well, then there weren't inconsistencies, right? That type of thing. And it kind of, I guess, in a way to salvage the fact that the Commonwealth didn't want to use these in the first trial. Oh, here we go.
That are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were two different interviews that were turned over. One was represented at the last hearing, that it was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was represented in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions, they were significant. In addition, which is notable, and you can glean this from the transcripts, is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson 33 times. And so there are significant interruptions and redactions in both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redacted portions, there is conversation or consultation.
Here's what I want to say right now. So as of where we're at right now, part of the challenge with the first part of what the Commonwealth is asking for, again, wanting Karen Reed's parents' phone records, the thing is, right, like we know how it works when you've got subpoenaing records from a defendant, right? So, but the thing is that this is their personal phone records that they're asking for. So that's a bit of a different standard there in order to, invade someone's privacy, really, right? Because again, they're not defendants, they're not involved. And so that's part of why this is sort of a challenge. It'll be tough to say if that, I don't know. I just feel like with Judge Bev, right? It's like she's so prosecution leaning that I feel like she's going to grant it. But I feel like most judges would have a hard time doing that because of the infringement on their privacy, because they are not parties to this case. But the other thing that's interesting about this part is that these redactions, right? So this is where I think they have a much stronger argument and is standing here, because well, he's going to explain it more, but there's like, in other words, it's almost like this record is incomplete, right? And in this case, it's different because, as we know, Karen Reed's statements can and will be used against her. And even though they're made outside of court, right, it doesn't matter because she's the defendant. So the other thing that makes it challenging is that now you've involved this other party, the other party being Gretchen Voss and the Boston magazine that she works for. And then, there was another thing I was going to say that makes it more complicated. I'll think of it as we go along. Let me keep playing it.
Or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements. That bears directly on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them.
Right.
They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of the defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview.
And so, of course, right, because the reason they're not hearsay, right, is because they're statements by a party opponent. But I remember the other thing I was going to point out. The other thing that makes it more complicated is that all three defense attorneys were present for this interview. And so, will we run into a situation like we've had, like, because of the fact that they want to make Gretchen Voss a witness to testify in this trial, are we going to run into an issue now where, the attorneys are also witnesses? Now, this happened, if you guys recall, when it came to the jurors that spoke out after the first mistrial. And remember, they submitted these affidavits in support of the juror statements, and that's why they had to bring in outside counsel to represent Karen Reed in the matters, the post mistrial matters, because of the fact that by submitting those affidavits, her attorneys made themselves potential witnesses. Now, that didn't apply to Ms. Little, and when it comes to the juror statements, that was just Jackson and Unetti. However, for this interview, as we're going to learn, all three were present. I think it was this interview. If it wasn't this interview, it was a different one. But or it might be all of them, but we are going to learn at some point that the attorneys were also present. And actually, having said that, the fact that he's mentioning these large redactions, then yeah, the redactions are things where Karen is going to say something, and then her attorneys, something happens. We don't know because it's redacted, right? And her and her attorneys are talking back and forth. And in this case, it's not privileged because there's a third party. Again, makes it more complicated. Gretchen Voss being there, right? Now it's not attorney-client privilege because there's a third party. So that's why everything that is being discussed is really, technically, it's fair game for the Commonwealth. And what the defense turned over was redacted for things that they chose, right? So I think this is a strong argument for the Commonwealth.
It is what is missing in the redactions. Now, certainly there may be discussions in those redactions that involve her attorneys and Ms. Voss, but none of that is protected. None of that is protected.
Right.
The defendant enjoys many privileges, but when an accused decides to cast aside the privileges, they don't.
I would say they're more like rights. Hi, Candace. Happy to see you.
In our jurisprudence,
how's your daughter doing?
To be able to do that, they enjoy Fifth Amendment privilege as they should. A defendant is presumed innocent, but when they cast it aside, it's at their own peril. They have an attorney-client privilege, but when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview is that we have three attorneys.
Okay, there it is. There it is.
Reporter,
yep.
Having a free reign of interview, and then later deciding what parts of the
and again, even before even just to pause right here, just to reiterate that already now, that's complicated because again, you've got all the attorneys present, and that could make them they could be making themselves witnesses. And again, and now you've got also a third party, which is Gretchen Voss, and it's not just like it's a random third party. There's also the whole, again, the media company that she works for Boston Magazine. And that's why I think it's so interesting that they indicate, the Commonwealth indicates they want to actually call Gretchen Voss as a witness. It's interesting because again, I hope it doesn't create additional problems. If this does come in, I hope this doesn't create additional problems for her attorneys having been there. And again, they're technically witnesses, right?
They want the public to hear. What parts of the interview they want the Commonwealth to have possession of? They don't have, respectfully, that choice or that power or that discretion. They can contract with each other,
Glad to hear
have their own
she's being
side agreements of what
this.
they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial,
Here we go.
have her on the stand.
There
And I
it
was
is.
to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about.
So here's the other thing. Here's the other thing. This is why I think it's so interesting, because they don't have to call her, right? Like, this is one thing I want to talk about, because he mentioned there's a transcript of the interview and there's an audio recording of the interview. And then you've got the people that were present: Karen, Gretchen Voss, the three attorneys, you know, camera people, whatever. So there's a number of ways this could come in. Now, of course, this is early. This is just getting the discovery, right? But just thinking about this down the long run, if it does come in and they seek to use it in trial, right? If it's admissible, there's different ways it could come in, right? Which is why I find it so interesting that he's saying he's referencing it coming in through calling Gretchen Voss as a witness. And I think that's a strategic move on his part to try to outline his argument as to how these statements are admissible. So, and the reason I'm saying this is because, you know, they can't call Karen, like the Commonwealth can't call Karen, right, to be a witness, you know, because, right, 99.9% of the time, right, when we have evidence that's admitted in a trial, you know, there's a witness on the stand. However, there's also exceptions where things are stipulated to. And honestly, we saw examples of that in Ezra McCandless, and there's also a lot of examples of that with Casey Anthony, where whether it's a video, whether it's photos, whether it's a 911 call, whatever the case may be, both parties have stipulated to it, and there's no witness to bring it in. So, and I think this even happened in Sarah Boone. Yeah, it did happen in Sarah Boone also. So, so if the parties stipulate, right, then the evidence comes in, and then the judge will read the jury, explain that, you know, both parties have stipulated. And so in other words, and that's where this gets interesting, right? Whether it's the transcript or the audio recordings or both, right? The parties could stipulate. And that way, because they can't call Karen, right? But that way, there's no need to call Gretchen Voss, and there's no need to, and then of course, the other people would be her attorneys, right? And so I think that's why between you've got Karen, then you've got the attorneys, and then who's left? Gretchen Voss. I think that's why he's saying this, and he keeps mentioning about calling her, because it bypasses the acknowledgement that that's not necessary, because they could stipulate to, again, the transcript, the audio recording, or both. But by skipping all that and just kind of almost like saying, we're going to call her at trial, blah, blah, it allows him to then explain why this information is necessary in order to examine her on the witness stand, if that makes sense.
Thank you. That's all it is. And, you know,
But like, in other words, it's an extreme measure in my view, because it's not necessary. And we're going to hear more about why this is a big deal.
Oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably,
right,
all three of the attorneys are witnesses as well.
Oh,
now,
you know what?
That was not heavy-handed.
Well, there you go. I hadn't heard that part, but that's what I was just saying. So scrolly crystal ball.
The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put
So this again is so interesting, right? Because they can't call Karen. Like I said, they can't call Karen. He's saying, look, we're not going to be mean. We're not going to try to call them and you know, destroy everything, blah, blah, as if it's like we're being nice, blah, blah. So because of that, that's why we're calling Gretchen Voss. Again, they don't have to call anybody. They could stipulate. This is a strategy.
Attorney in an uncomfortable position.
To try to make it seem like they're doing the least invasive or least disruptive measure when they're really not. And we're going to hear more about it.
They're all witnesses to a substantive statement.
Yep.
many of them admissions of guilt, contradictions, all of them. And the most respectful way to pursue those, the strongest way, the fairest way to pursue those with moderation is to get them from Emily Voss in the interview that exists.
I mean, yeah, I do agree. They deserve
In
to
the
have,
meeting, they received
they 100% deserve to have those redacted statements, I believe. I think that calling Gretchen Voss as a witness, again, we're going to hear more about, I think it's unnecessary, and I feel like that's a strategy, and that's a bridge too far, or more than one bridge too far, but I do believe they should be turned over that information that was redacted.
I mean, I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on two propositions. Number one, Commonwealth versus Doe, promulgation, those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it. There's a difference. And Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced because there is none. The cases are dissimilar because they deal with trying to get to a confidential source that may expose a source that may not be used at trial anyways because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this continually. And although an attorney cannot produce evidence to the public or encourage it, it violates the rules of professional responsibility. They cannot have a statement that is meant to reach.
Well, okay. Now you're pushing it again.
Does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to. She's presumed innocent. She can make all the statements she wants. But when she does, there is a consequence for that. And they now bear the consequence of these statements that have been made. And so, since it is not a confidential informant, it's a very public, identified.
And that's why
herself. The argument of Doe.
That's why it's really crazy that, like, I was shocked. It's one thing that the interviews she did back in the day, but especially when it comes to that Vanity Fair article, right? I remember I heard about that from Super Planner Girl. Shout out to Super Planner Girl. And I was shocked because I'm like, what? She knows better. Her attorneys know better. And they know all this can come in. And what were they thinking? It's really crazy. Yeah, I guess that's why they redacted so much of it. Maybe I don't know. Like,
has no merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize.
And this is where it gets even more complicated. So Gretchen Voss, again, they want to, the Commonwealth saying they want to call her as witness. Again, they don't have to, but she's afraid for her safety, which is odd because she's only the person who she just was the journalist, right? That did but I mean, I suppose because of the strong, I don't dispute that. It's just crazy that it's risen to that level, in other words, right? Because it's like, she's just the journalist asking the questions. But anyway, but that's why it's even crazier, right? Because she's afraid for her safety and, and she does not want to be called as a witness. And we're going to hear from counsel as well, representing Boston Magazine, the company she worked for or still works for. And so in other words, it's like, it's not necessary to have her come in as a witness. But beyond that, she's afraid for her safety. So what are we doing?
In this case, firsthand, I've never seen anything like this, where witnesses have to fear walking out of their car. It's repugnant. It undermines the fabric of the judicial system. But Ms. Voss isn't alone, and I have empathy for her. Almost every witness, civilian witness for the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think.
There's a big difference, and here's why. Again, Gretchen Voss is only a witness in so much as she asked those questions for that interview. But again, all of that, there's a transcript, there's the audio recordings, that can come in as being stipulated to. It's completely different when you look at the McAlberts, right? Because that can't be stipulated. They themselves are the witnesses to what happened that night or their version of it. And there's no way around it unless you just don't call them, right? There's no other way to get that testimony in. In this case with Gretchen Voss, there is another way to get the evidence in, right? Because the testimony from her isn't the important thing. It's the evidence of the interview, but that already exists without her witness testimony. So
the level of harassment and intimidation that someone must suffer because they're simply a witness in the case. And my empathy is to Ms. Voss, but to every other witness in this case, she's in no different position. It does not impede the progress of the Commonwealth. It does not impede the fact-finding mission. It's unfair. It shouldn't happen. Something should happen as a result, but it has no bearing on the analysis.
You don't have
in
to
this
call
case.
her, sir.
It just doesn't. And so there is.
This is like the straw man argument. And he's done this is like, I think he did something like this earlier. It's like, well, I guess it was still with Gretchen Voss. Like this whole Gretchen Voss thing to me is like the straw man argument of like, you know, look, we're picking the lesser of two evils. We're not going to call the defense attorneys as witnesses. No, you know, we're being nice about that. So we're going to call Gretchen Voss instead, right? When that's, again, that's a straw man argument. And again, here, like the fact that all these witnesses are being threatened, but like that, you know, they have a right to call her as a witness. And, you know, what was the other thing that he just said? Right. Fact-finding mission. She's no different. Again, it's a straw man argument because you don't have to call her. So
the progress of the Commonwealth. It does not impede the fact-finding mission. It's unfair. It shouldn't happen. Something should happen as a result, but it has no bearing.
Right. And the other thing, so he's trying to make it all about people being unfair to the witnesses. And again, what you're saying should have no bearing because it's really, in this case, it doesn't have to happen.
It doesn't.
Frustrating.
And so
I liked you better the last hearing.
A ton of conversation that has been redacted arbitrarily by parties that want to use what's in their best interest, but cover up what doesn't help them.
I mean, he's right about that.
Entitled to it. And we're seeking it and we want it. We want all the redactions in the first and second interview. Over 75% of the second interview is redacted. We want the notes from the third interview. Ms. Voss is a witness. She wasn't at the scene. She didn't drive into John O'Keefe and leave him in the snow, but she's a witness to substantive statements, her statements, admissions, confessions. And those notes evidence the statements of Ms. Reed. They're clearly discoverable in the email or text message and phone
We know
call
that.
against statements of the defendant.
Yeah, they are discoverable, but they need to turn over these redactions in the transcript or the audio recording, give them the redactions, but you don't need to involve Ms. Voss.
Ms. Voss, reporter or not, is a witness in this case to some of the most crucial damning evidence in this case. We're entitled to it. We take no exception for it. Thank you.
All right, thank you. Ms. Birch.
Thank you, Robert Birch in court.
So now,
And Gretchen Voss.
okay, so he's representing the Metrocorp, which I guess is what the Boston Magazine is a conglomerate of, or whatever the word. And also representing Ms. Voss. And the other thing I will say is that while I keep mentioning the stipulation, that is really something that would come up if remember, this is just them trying to get the discovery, right? In terms of the admissibility, whether or not it's going to be entered in, all that. That's when, if this gets turned over, if this is granted, because this gets turned over, right? And then we're getting closer to trial, that's when those conversations would happen about the stipulation. But even still, he doesn't need to be doing all this with the whole calling Gretchen Voss to the stand thing. But what I just want to say is this could get turned over and it could be that they decide to stipulate, or they could decide to call her. We're going to see what her attorney says.
I've been here before, Your Honor, on a remarkably similar motion. And Your Honor, at that time, made a Solomonic decision and said that 2 audio tapes minus attorney dialogue and off-the-record comments would have to be produced. And the one-on-one off-the-record interview between Gretchen Voss and Ms. Reed did not have to be produced. And the Commonwealth has simply made no persuasive showing as to why the decision should be any different now. The Commonwealth makes much of the fact that there are heavy redactions on the shorter of the 2 taped interviews. They refer to it as a 2-hour interview. Actually, it's a 1-hour interview according to the affidavit of Gretchen Voss, which had been submitted with our original opposition to the first motion. So it wasn't quite as lopsided as counsel is intimating. But in any event, the reason for the redactions is that the Commonwealth made a point in its original motion that it was not seeking anything but the defendant's statements, that it did not want colloquy of attorneys. It did not seek what the attorneys were saying. And it said that over and over in its original motion. Now it's suddenly changing the rules and says, oops, we've decided we want those after all.
Didn't I leave that open for them though?
And that's why I said, like I pointed out, remember, Mr. Brennan started with that argument of, well, because now, again, I think that's why you pointed out, like now in light of the newest interview, now it's like, well, now we think they're relevant because we're seeing contradictions, that him trying to kind of help out, get ahead of this argument here.
Didn't I leave that open for them to come back even at the first trial? To come back and request it upon review of the first?
I'm sorry, I didn't quite.
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now a new trial. We have different attorneys presumed with today's motion on both sides. So why are we focusing on what they requested first and what's different than now?
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorney's colloquy. And now they're saying the attorney's colloquy is central to what they need. They can't have it both ways.
Go ahead.
So actually, I found here, let me pull it up, the affidavit of that they just referenced, the Gretchen Voss affidavit. Let me show this to you guys. All right, so here it is. So here's the Gretchen Voss affidavit that they just referenced just a second ago. Can I zoom in? I can't zoom in. Okay, so I will read it to you guys. So this is affidavit in support of Commonwealth's renewed motion for all audio recordings, interview notes, emails, text messages. Wow, now we've gone way further. And voicemails in the possession of Gretchen Voss and or Metrocorp. Her text messages? Okay, let's just see. I, Hank Brennan, hereby state that blah, blah, blah. I'm the special prosecutor. So now he's submitting an affidavit. Remember what that means, guys. He's now technically a witness. I'm the special prosecutor assigned the defendant's case. I'm moving to produce records in the above captioned matter. The Commonwealth alleges that, right there, you're alleging she killed John Keefe. After arraignment, the defendant has appeared in interviews with numerous media outlets, included but not limited to interviews given to Gretchen Voss, and that's from Boston Magazine, 2020 Dateline, and Vanity Fair. The Commonwealth's Rule 17 request includes the request previously made by the Commonwealth, along with, so now they're bringing that back up, along with additional requests not previously added that are relevant and material. Undersigned counsel has listened to all the produced audio relative to the defendant's interviews with Gretchen Voss and has separately read transcripts of both interviews. The Commonwealth's motion is made in good faith. It is not a fishing expedition and is likely to produce relevant information. But what's the deal with wanting her interview notes, emails, and text messages and voicemails? I mean, I guess interview notes, fine, but you don't need her, and you don't need anything else. You just need the transcript and audio recording, right? I mean, it seems a bit much for me. So now let me go back to the hearing.
Change of subject from one before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that has the impact of serving as grist for impeachment at trial. And one has to wonder whether this motion is really an effort to keep Ms. Voss off the stand and off from reporting, because she, in fact, has suffered, as Your Honor noted at the earlier hearing, from harassment. And Your Honor noted in your order that the disclosure of the material sought would require her to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. That's what she averred. And her affidavit also details the harassment she's endured since the publication of her article, and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she will be exposing herself to further harassment and endangering the safety of herself and her family. And Your Honor, the extraordinary public attention and scrutiny given to this case and her fears for her own safety and that of her family are no doubt warranted. And in light of the concerns set forth in her affidavit, the court concludes that the asserted damage to the free flow of information is more than speculative or theoretical. You said it was a close call, but given making the division.
And the thing is a lot of what he's arguing is because, like I just pointed out, since we just looked at that affidavit, the over-broadness, he's not arguing that they shouldn't get the redacted statements, because that's not his argument to make. That's the defense team that redacted it, right? He's arguing because, and only because, the Commonwealth also asked for interview notes, text messages, emails, and voicemails. Well, yeah. I mean, I just don't know why. I feel like there's a simple solution here, man. You know, like, let's just ask for the things that are necessary and, you know, and just stipulate to it. But anyway, but yeah, I just wanted to point out that's what he's saying. He's saying, like, there's no need for this. It's going to cause her further concerns for her safety, blah, blah. And yeah.
I call the Solomonic division of providing some and limiting the others seem to make sense. So what are they seeking now that they didn't have before? Well, in addition to seeking the redacted portions of the interviews, which Metrocorp and its counsel undertook at time and expense to redact them to accord with what the subpoena as approved, what the subpoena as issued had asked for. They're asking now for the handwritten notes of Ms. Voss, the one-on-one off-the-record interview that she had with no attorneys present. Those are handwritten notes. There's no audio tape. They are partial notes. They are they're phrases. They're not complete thoughts. They're more jog memory sorts of telegraphic mentions. So it seems likely that if required to turn over these notes, which essentially represent the work product of the journalist and her personality as expressed in her,
right,
what she takes from the interview,
right,
if forced to produce
that, and that's not necessary or relevant.
Steps if the Commonwealth is going to want to depose her or call her a trial in order to explain those notes and interpret them. And that's going to take us down yet one more rabbit hole in this case. I've just already had so many.
There's a Paul O'Keefe there.
It would also have the effect, maybe the calculated effect, of preventing Ms. Voss from covering the trial.
Right.
Because if she is called as a witness, she is not permitted to sit in and the courtroom for the proceedings.
So now she can't do her job because she covered the first trial, and now she's not going to be able to do her job if they call her as a witness.
She did attend the last trial, right?
She did,
on a daily basis. Right, on a daily basis.
I believe so. Yes.
Okay.
Every day. Yes.
Okay, thank you. And that was Ms. Voss who just responded to you?
I'm sorry.
That was Ms. Voss who just responded to you, yes, correct?
Yes.
Yeah, so that sounds like Judge Bev did not know what Gretchen Voss looked like, so that's why she asked that question. So Gretchen Voss is there in the courtroom. I mean, yeah, this is incredibly unfair to her for the safety, for not being unable to cover his job. And again, unnecessary.
And finally, the Commonwealth asks for the first time for texts between.
Yeah, sorry,
Ms.
no.
Reed and Ms. Voss.
No.
We do have texts. They are.
So, I mean, what Judge Bev could do here is she could grant in part and deny in part. Like, in other words, she could say, yes, you can have, you know, I don't know, some of the handwritten notes or, you know, some of the transcripts or whatever from her, but like deny it for like the text messages and the voicemails and you know, things like that. You know, or, you know, she could just deny it altogether because the Commonwealth asked for too much. I don't think she will, because again, you know, some judges would, right? But if you really want to be helping out the prosecution, Commonwealth, then you could, you know, grant in part and deny in part.
The manner in which they get forwarded from an iPhone is that they come out without the name of the speaker. You can sort of guess at the name of the speaker, but you don't see the name of the speaker. You also don't see the date and time of the communication. I'd ask that we're willing to turn those over. They were not off the record, but I ask that we be able to turn them over in that form which is the form you have them in, rather than go to whatever expense and trouble to replicate a different format.
Okay.
And that's all I have.
All right. Thank you very much. Mr. Brennan, I'll give you a chance to respond, but I do have a question for you based on Mr. Birch's opposition. If you've got the opposition with you, Mr. Brennan? Okay. So what I'm going to ask you to respond to is on page 5. First full paragraph, the paragraph begins that this litigation, but the sentence is, in other words, the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging admissions by Reed or reveals that she was not entirely forthright in her unsworn press interviews with Voss. What do you say about that? You touched upon it when you started your argument today about inconsistencies. What's your argument to that specific?
Having received this morning, having not had an opportunity to read it, could I just have one moment to read it in context?
Sure.
Thank you.
Okay, so he's going to read it. Let me, yeah, the inconsistencies. So let's go forward a little bit if you can.
This
Oops.
because of ideas.
All right. Paul O'Keefe.
This posits two separate ideas, the way I interpret it. The first is the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging omissions by Reed. The audio provided thus far contains many damaging omissions to Reed. In her first interview with Gretchen Voss, she talks about when she dropped John off and where she dropped him off. It's noticeable in many, many interviews, the story changes. At one point, she has them going to the side door of the house. In fact, in 3 of the interviews, he's going to the side door of the house.
But, dude.
In a further interview, she says he went to the front door of the house. It's not subtle. There's a reason.
When he just a couple minutes ago, right? He actually said confessions. He didn't. He said he did reference inconsistent statements, but he said confessions as well. And the example he just gave is like, oh, they went through the side door, not the other door. I mean, come on.
And the versions given by Ms. Reed evolve in time. Coincidentally, they evolve sometimes with the production of Discovery. And so I am not suggesting for a second that there are no damaging statements by Ms. Reed. In fact, there are confessions, there are admissions, and there are
There it is again. Confessions. Confessions? Confessions to what?
All I can simply say is that is not the Commonwealth's position. That is stated wrongly. Also, or it reveals that she was not entirely forthright in her unsworn press interviews with Voss. Well, we're entitled to take her statements with Ms. Voss and compare them to all the other statements she made. 2020, Vanity Fair, Dateline, and
there you
others.
go.
And so the question isn't whether her statement to Voss or Ms. Voss is accurate. It is in comparison to other statements. Is it accurate? And we know that it's not. There are many instances where she has given different statements between versions.
But that doesn't make any sense because how, if you're contending that the statements to Ms. Voss are not accurate in comparison to others, again, this is like a logical fallacy because the same could be said about any of the other statements, right? If they're all inconsistent from each other, then what you're basically saying is none of them are true, or you can't prove which ones are true, right? Like that's what he's saying. It's not like, you know, this statement's true and these other ones contradict it. It's like they're all contradicting each other. They're all inconsistent. So you're just, yeah, hopefully you guys can see the logical fallacy there with that argument of pitting the statements against each other when they're all inconsistent. And how can he suggest which one is the correct one, you know?
Also internally in Ms. Voss's interview, as I mentioned,
I know, right?
Redactions.
He did. It's crazy.
Return in a different statement. For example, she was only sipping at the waterfall, which would suggest further drinking. And then after a redaction and interruption, she's sipping water at the waterfall, as incredulous as that may be. And so clearly something happened during that redaction that changed the admission to drinking alcohol, which is part of this case, to something of water. And so I think that
that doesn't surprise me.
In this motion really has no relevance to the analysis. It's not on point. The reason I said there was a 2-hour interview, and I'll accept that I'm wrong, is when I listened to the FTR tape, counsel respectfully said it was a 2-hour interview. And that's where I got my information from, not Ms. Voss's affidavit. So it may have been a 1-hour interview, which still leaves us with 1/3 of the interview, 2/3 redacted. That is significant. The Commonwealth comes back, we're entitled to come back when we want, if we have a good faith basis and if the court invites us. We come back now after I've had a chance to actually listen to 4 hours of interview, or you add them up, 3 hours and 40 minutes of interview. I've studied them. I've listened to them many times. I've ordered transcripts. I've perused the transcripts. I've compared the two. I've compared them to all the other statements. So time has now made these much more relevant than they maybe initially thought. I can't speak for the Commonwealth at that point. We're entitled to the full force of our proof. We don't have to just take some. We don't have to take a fraction. Just because it's inconvenient or uncomfortable for parties, the government is entitled to the full force of their proof.
You don't need
Representing the
to
people of this
make Gretchen
Commonwealth
Voss
and pursuing the
uncomfortable
full
to
force
do
of our proof
it.
in every aspect, because we're entitled to it. It is notable in the FTR hearing that counsel for Ms. Voss and for the publication said that the third interview they discussed, and the parties, meaning the defense attorneys, the defendant, the defense attorney, the defendant, and Ms. Voss could decide to use that material. It wasn't that it was precluded or no one could ever see it. It's only if it helped them. And so he said that they agreed that if they wanted to, they could use that material. They just decided not to. Because they decided not to use incriminating information in their story doesn't give them the power to decide who does and when they do. So we're entitled to the full force of our proof, and we're going to pursue it. We're entitled to all of these records, all this information. There is no legal argument against it. None.
All right, thank you. So I know, Ms. Little, I asked if you wanted to say anything. I just give you that opportunity. Was there anything you wanted to add? Okay. All right, so that is taken under advisement.
Of
Now
course
we
it
have
is.
3 more motions. I understand Mr. Albano is here, who will be filing an appearance if on all 3 or arguing all 3. But so Mr. Albano, you can come forward, sir. And Mr. Brennan, do you want to argue each one of these individually? It appears I did get a.
So these I'm thinking are going to be the other media outlets like the 2020 Dateline and Vanity Fair.
Position this morning that goes to service, which pertains to all 3. But do you have different arguments, a little bit different on each?
I do. Okay,
So Mr. Albano, do you want to be heard after each argument, or do you want to just be heard at the end of the 3? There are 3 motions. FXT TV, Boston 25, WCVB TV, Hearst Television Incorporated and ABC, and NBC 10 Boston. Okay, thank you. And again, on these, Ms. Little, you don't expect to argue? Okay. If you change your mind, just stand up and let me know. No,
This is just going to be between then the Commonwealth and the attorney representing, or attorneys plural, representing those just aforementioned different media outlets. Also, shout out to NBC. What was it? NBC 10 Boston, because that's that's who I used to live stream. Well, that's who I used for the entire trial, but also for this very hearing right now, because that's who is streaming it.
All right, I will hear you. Why don't we start with the FXT TV, Boston 25, it's paper number 400.
Oh, wait. Boston 25 might be the one I use, actually.
as has been discussed, Fox 25 and its employees conducted an interview of William and Janet Reed. I quoted on subsection 5 some of the language from that interview. And during my quote, it says, during your first discussion with Karen. It should say, during your first discussions with Karen. There's an
No, it's NBC 10 Boston. Anyway, I'll back it up and say, I just wanted to, I double checked. It's NBC 10 Boston. That's who I actually use. But they mentioned them again at the end. But yeah.
Janet Reed. I quoted on.
In other words, Karen's mom gave an interview.
Subsection 5.
Boston 25.
Some of the language from that interview. And during my quote, it says, during your first discussion with Karen. It should say, during your first discussions with Karen. There's an S left off. Nevertheless, during your first discussions with Karen, did you believe she may have hit John?
Did she believe?
Yes.
Okay, I thought you said, did you believe?
Then I misspoke. My apologies. Did she believe she may have hit John?
Who?
William Reed responded, no, no.
Who?
Well, she struck something. She said, Dad, I think I struck something. I said, what do you mean, right? This was in the hospital, right? She says, I remember, all right, backing up and hitting something. I've had the benefit of at least looking at the phone records that are available for Karen Reed and seeing there was a phone conversation that morning to William Reed's phone. That phone conversation is before Karen Reed is admitted to the hospital.
This is where it gets really interesting. So here's the thing. Remember, just to refresh everyone's memory, yeah, her mom, but then there's also her dad, because now he's referencing the dad. This is where it gets weird, because it's like, who's talking to who? But here's the thing. So remember, we saw that video, right, of Karen backing up and hitting John O'Keefe's car. And it looked like there was taillight that had been punched out. You guys saw that video. And it looks like that's what happened, right? So when she says I may have, like, apparently according to the statement, right? She said I may have hit something. She didn't say John, right? I hit something. We don't know yet what but she could be referencing that she hit something, right? She backed because, you know, like if I bump into some. Hopefully you guys could still hear me. I don't know if the stream cut out, but he's going to try to verify. He's going to try to prove, this is my thought. He's going to try to prove or attempt to prove that when Karen said she thought she hit something, he's going to try to prove that she meant John because of the time of the phone call. Whereas if the phone call was later, right, then she could be talking about bumping into the car because John was deceased, right, in the front yard, according to the defense, without Karen's knowledge, right? But that happened before she bumped into his car, right? So the timing of the phone calls is going to matter because if the phone call was, you know, I don't know, between like 2 a.m. and 6 a.m., say, right? I don't remember exactly the time she bumped into his car. We'll probably hear about it. But then that could be what she's referencing, right? As long as the phone call was after the timestamp of that video of her bumping into the car, right? But if it's earlier, then that's different. But we're going to hear, this is going to get really interesting. So.
And so it is by inference in the back of a police car. At
Her mom and her dad.
Now there's some ambiguity during your first discussions. The operative word as I see it is first. It is a particularly remarkable statement to make that in the throes of realizing the great tragedy that's unfolding with John O'Keefe lying in the snow dying, that the comment of thinking that they hit supposedly now another car in a driveway hours earlier would be the topic of conversation at that point.
Well, it depends though. Again, depends on when they're talking because we'll see. I mean, again, she could have talked to them. We don't know yet. If she could have talked to them after bumping into his car, but before finding him, right? Because there was some time that elapsed there. Like, I don't know, I think a couple hours, but we'll see.
There is not a fair inference that would be the subject matter. It is not a fair conclusion that a person would be so fixated on a mere nudging of another car that caused no damage hours earlier.
Ew.
When we're dealing with the potential loss.
Ew.
And so I think it is reasonable to infer that that was actually not the complete statement. The conversation lasted on that morning for over a minute, and there was certainly conversations after.
Over a minute? Oh my God.
And so,
dude, if you're going to say that, then what are you going to say of the butt dials, right? It lasted for over a minute. Weren't those butt dials like that long or longer? Like if you're trying to exaggerate it like over a minute, it's probably a minute and 1 second, right? Trying to make it seem like that's a long phone call. Then what are you going to say about the butt dials, sir?
The defendant's father has, as he's entitled to, utilized media to try to.
Yeah. So both her parents made statements.
Sell a story to help his daughter.
Okay.
And during that airing, it is clear and obvious that not the entire conversation with William Reed has been provided. During these stories, oftentimes there is summaries to progress the episode much quicker. And so all of his statements, which may not be a lot, but all the statements to that employee of Fox 25 who did the interview should be discoverable so that this statement can be put into context. So
far, we've got statements made by Karen's mom to Boston 25 and statements made by Karen's dad to Fox 25.
Doctrine of completeness. We should know what the entirety of the conversation interview was
The
so
butt
that we
dials.
can assess this statement and draw the proper inferences from it. It is expected that William Reed very likely will be a witness at trial.
Yeah.
He will be asked about this conversation. He may be asked about what else he had said. It will be impossible at trial then to try to.
This is the same strategy. Are you guys seeing the pattern? He's employing the same strategy he did with Gretchen Voss. What's he saying? He's like threatening. I feel like what he's doing here is like threatening to call people as witnesses, which is really, I don't like this at all. I mean, is he actually going to call Gretchen Voss? Is he actually going to call Karen's dad to the stand? I mean, again, he doesn't actually have to. What they're asking for is the discovery, the actual statements themselves. You don't, I feel like I'm beating a dead horse, but like, you don't have to call them to the stand. So I feel like this is just a tactic to like, I don't know, make them feel afraid, or I don't know. I mean, her poor dad is sitting right there. And, the thing is like, imagine it, right? How good would it really go for the Commonwealth if they call her dad to the stand, right? Or her mom to the stand? Like, that's why I'm like thinking like it's a bluff, right? Because like, I don't know. That seems like not the smartest move.
The other statements that he has made to this network or this employee. And so the Commonwealth or anybody who would be questioning him would be just simply left to the whim of his answer. And I'm not satisfied to do that. I do not think there is any protection. He is not a defendant. There is no privilege. And so there is no reason to protect this information so that it can fairly be brought into context so that when he's cross-examined, if there is evidence of impeachment or cooperation,
Again, indicating he's going to call him.
The substance of that material.
I feel like that's not a smart move, but that's just my opinion. What do you guys think? This really could all just be a strategy to try to intimidate the defense, right? Or just to intimidate her dad. Maybe it's to intimidate them into saying, yeah, just give him whatever he wants so that he doesn't call us as witnesses. I don't know. It's interesting.
That is the reason we request the pleading in number 400 for the Fox 25 footage that was not aired.
Okay. Have you had a chance to read Mr. Albano's opposition this morning? It's not very long.
I haven't, but I can say Mr. Albano kindly called me. He outlined the issues in the email. He made this a much more streamlined and agreeable process. And so I credit him with his effort. I don't need to read his response. I'll appreciate what he says.
Okay. That sounds like a slight to the other attorney who was representing Gretchen Voss.
Interaction with him, his total candor, I have no hesitation what he says in his representations. I might disagree, but I don't need to read his pleading.
Okay.
There are two, NBC and ABC. If Your Honor would allow me to start with NBC, because I think we should streamline that.
All right, that's going to be 2020 Dateline.
NBC 10 has agreed to give promo materials in their possession. I've not only spoke to Mr. Albano, but I spoke to the attorney for the subsidiaries that we also had subpoenaed. And they told me that as subsidiaries, they do not have possession of the materials of the parent company.
Right. So Boston, NBC Boston or Boston 10, they're a subsidiary of NBC, right?
Letters from the attorneys stating as much. So as it pertains to NBC 10, the position is that one of the subsidiaries is going to send us promotional materials.
Oh, and don't worry, we're going to hear in just a few minutes or shortly here, there's a little fun little treat, if you will, in that we're going to hear a little bit about the DA, Morrissey, and what the defense is also, again, that's the defense has something that they're asking for, and it has to do with the DA. So we're going to hear about that too coming up, speaking of corrupt.
And as far as service on the parent company, I don't think the Commonwealth succeeded, despite the fact that we made numerous efforts in hand, mail, UPS to a number of subsidiaries. I don't think we satisfied, so I do not want to ask the court to progress that.
Okay. Do you have a timeline on when you'll get this material?
The promotional materials?
Yes.
They said they were putting them together. I did not ask for a timeline.
Okay.
The promotional materials are a very small fragment. It's I've only seen one clip aired. I don't know what else they have, but it should not take them long.
Okay. I don't have a paper number. Jim, do you have the paper number on NBC 10? Here, just you know what you need, you can give it to me after. I don't have that paper number or the other one. All right. So do you want to?
427, Your Honor.
I have to say, I do think he's got a very spiffy suit, three-piece suit, right? He's got a little vest on. Very nice.
427. All right. So do you want to move on to CVB TV?
Yes.
Okay.
WCVB TV has been served, and they've.
It's interesting because, again, thinking about the contrast from this hearing and the last hearing, they covered a lot of issues in that last hearing. And again, I commented on it, even at the beginning of this live stream. We watched the little mashup I did where, you heard me say it, you heard Peter Trago say it, about how both sides were getting along and agreeing on so many different things. And it was just very much like agreeable and like blah, blah. It's interesting to me that with all the topics discussed at the last one, because they didn't get into this stuff, right? Judge Bev thought they were going to talk about these Rule 17 discovery motions. She thought they were going to cover those. And apparently that expectation was not, Mr. Brennan didn't understand that was her expectation. That's why they're having this hearing. So they didn't cover those. So they covered all the other stuff, right? There was a lot, telemetry, the witness list, expert witnesses, blah, but they were like very congenial. It's interesting to me. I'm noticing this is a very different tone to me. And I find it interesting that out of all the stuff discussed in the last hearing, including all the telemetry, right, that they didn't have all the telemetry data and they're getting the expert witnesses, they're going to do a chip on, that seems like that's going to be like, okay, that's like going to make, you know, if you're him, you're brought in as a special prosecutor, you're going to try to make this work for the state, even if it means, you know, I don't know, maybe you drop the second degree murder trial, you know, whatever the case may be, right? You're going to try to find a way to salvage the disaster that is this case, this trial. And, you know, and so you would think that that would be the thing you'd get really amped up about, right? And like really push for. What's interesting is that this is where the fangs, if you will, or the claws are coming out a little bit. And I'm saying that because, again, I think that this whole thing about I'm going to call the dad and I'm going to call Gretchen, all of that is unnecessary. And that's where it's like, okay, this is very different because, again, trying to intimidate, you know, bluffing, but the reason I'm saying this is because isn't it interesting that the thing that he's really fighting for is Karen Reed's statements to the media and Karen Reed's parent statements to the media. But he wasn't fighting like this for the telemetry. And he wasn't fighting like this for whatever else it was, you know, the different bits about the expert witness and stuff. Again, stuff that seems like that should be really critical. He didn't have to, there was no, he didn't make any arguments that were pushing it or, you know, it was just very congenial, you know. This is very different. I just find it really interesting that this is the thing he really wants, and he's willing to do whatever it takes to get it, right? It's interesting. And I feel like that says something about this, right? Because as he's new, he's not been here on the case for that long, right? He's just getting into it. We even heard him the last hearing 2 weeks ago say, I'm still learning the case. I'm still going through everything. Has he been going along and seeing this is our only hope? Maybe. That's certainly what this is looking like to me right now, this juncture.
That they're not in possession of the materials, have no control over the parent company, and they are not part of the company. And so
he's really fighting
I no
hard
longer
for these.
am asking WCDB-TV to produce these materials. Instead, in the alternative, we have subpoenaed the registered agent in Massachusetts, the registered agent for the parent company. They have been properly served. If we look at the Secretary of Commonwealth of Massachusetts Business Entity Summary website, not only do they have a principal place of business in New York, but they also have, as a registered agent, a local address, 84 State Street. So
this is going to have another overlap with Kohberger because basically what he's saying is NBC, the parent company, right? This is where it gets tricky, right? Because jurisdiction. So they've got two different addresses and they're in different states from Massachusetts and different states from each other. And again, where this kind of came up in Kohberger is like, well, which law applies, right? Or do we use Idaho law because that's where the crimes happened when we're discussing the validity of the search warrant and the arrest in Pennsylvania and what about Washington, right? There's three different states involved in BK, which is easy to forget about. I always just think Idaho, right? There's three states involved, but then there's also the FBI. And then the other layer to that was the fact that, you know, what the defense was kind of hinting at or suggesting in a way is that the reason Moscow PD brought the FBI in and then kicked him out post haste, right, is because the standards for obtaining probable cause for a search warrant are so much more lax with the FBI. And the reason is because the states, they can add to the Constitution for each state, right? They take the US Constitution and then state by state, they can add to it. They can make it, but they can't take away. And that's on purpose, right? So in other words, the lowest standard, right, for in terms of probable cause for, you know, search and seizure is going to be the U.S. Constitution. And some states might just have the same standard, but Idaho, as they pointed out, and they also said Pennsylvania as well, have those states have additional elements that they actually kept calling it the uniqueness, Idaho's uniqueness, right? That they are protecting the privacy of Idahoans. That they value privacy perhaps more than other states do. Like they have higher standards. So they were suggesting that perhaps, you know, getting the FBI involvement is because if they're the ones that are, you know, are going to be issuing a search warrant, they use the federal standard from the U.S. Constitution, and that standard is different. So it's like venue shopping, right? I think they actually even referenced that in one of the motions to suppress, like venue shopping, right? I think he might even say something very similar to that when it comes to this predicament, right, with NBC and the different states that it has addresses in, because the rules will be different. And then which one do you choose?
Position relative to the ABC materials is that ABC has been
Or ABC.
properly served locally.
Oh, okay.
Unlike NBC that did not
Right.
have a local registered agent that we could find, or perhaps does not have one, ABC
Right.
does.
So ABC has, this matters. So ABC has a local agent, which means they can use their Massachusetts, case law. They can use their Massachusetts, their state constitution, and that's all fine and dandy. But then, of course, the difficulty here, they're saying NBC does not have a local agent.
ABC does business in Massachusetts. In fact, these interviews with Ms. Reed may have taken place in Massachusetts. I don't know.
Oh, that's interesting.
But they have
That you
roots in
don't know.
Massachusetts in that they do business there. They have a local registered agent. And the reason to have a registered agent is to accept service, provide notice in cases of objections, and to provide materials. It is done routinely in civil cases when a registered agent is notified. They are then obligated to get materials even if the REM exists in a different place. Their position is that the REM exists in New York. That is irrelevant to the assessment in this case. To suggest that somehow the physical property being in another jurisdiction is not in the control or purview of the local registered agent would just be enacting a shell game where local companies could pick jurisdictions they find most favorable, do business in outside jurisdictions. And
There it is. That's the venue shopping house.
Consequences of that. That I don't believe is how the law is set up. As a registered agent, they are the same as the.
I know, right? I was thinking the same thing, Candace.
Contact to accept all types of service, communications, and responsibility. And so our position on ABC as far as service is concerned is they've been served through the registered agent, and therefore whatever materials exist, regardless if they're in Massachusetts or in New York, they are required to obtain them and they're required to produce them.
Okay, so Mr. Albano disagrees with you, and on the third page of his memo under paragraph 5, so I will give you the opportunity to read that.
Okay.
Under that fifth paragraph. Do you want to address the substance of your motion?
There she is helping him out, right? So because remember, he was like, I don't have to read it. I got the email. I talked to him, blah, blah. But she's helping him out because in other words, there's a part. So it sounds like Mr. Albano or whatever, he must have something that he's making in his argument that is strong enough to where she's like, hey, you missed this point that he made. You might want to take a second to read that and go ahead and, and then make your argument, right? In other words, it's just so nasty, right? Like she shouldn't be. He said, oh, I'm fine. I don't have to read it, blah, blah. Like, and then she's like, well, you should read it because you missed this part that's important. And, otherwise I'm going to have to it's going to be more favorable for Mr. Albano, right? So
regarding ABC.
I do. Much like other.
It's like giving him another chance. Like you forgot to make this argument about this particular issue. And so let me give you another chance and point out to you where you missed it.
Statements.
Gross.
We see from the Nightline in the 2020 interviews, there are a number of public statements that Ms. Reed has made.
So apparently we heard in the last hearing, I guess he didn't have paralegals initially. Now remember, he's brought on as a special prosecutor, but what he said in the last hearing was that he actually had brought on, so because he's a private defense attorney, right? That he actually has brought on his own private paralegal, I guess from his own law firm. It sounds like at his own expense is what it sounded like. I've heard people say conflicting things. They're probably just guessing. I don't think anyone can possibly know factually what their financial arrangement is. I think they're just guessing based on what he said, which we all heard it. And he said, I brought on my paralegal from my, my own law firm, something along those lines, right? That could mean you brought her over so she can't do the other work, but that doesn't necessarily mean that you're paying her. It could be the Commonwealth. We don't know who's paying her. Anyway, point being, he did bring on a full-time paralegal from his private firm to assist with this. But I don't know where things are getting lost in the shuffle. So
national audience that don't reconcile
things are
with
slipping through the
other
cracks.
statements made at other times. I've given you the example of not knowing which door she supposedly saw John and Keith go into.
That's so
There
stupid.
is differences in her stories and versions about where she was that night after.
And we know that house has a bunch of doors and they're all right next to each other. So that's stupid. I'm sorry. Come on.
Keith house. There is a number of examples where the different versions given contradict each other. And so although they're all substantive statements, they're all admissions and confessions, they still have a value in the fact that they contradict each other. And so
What about the fact that all the witnesses that the Commonwealth called in trial number 1, all the issues, dude, talk about contradictions, right? And meanwhile, did they see a body? Did they see a black blob? Did they see a shadow? Well, I mean, it was all, dude, every single person had a different thing about, did they see the SUV? Did they not see the SUV? Who was driving? It was a mess. It was a mess.
Episode that is aired on 2020 and Nightline, you hear oftentimes the author of the story, not even the interviewer, the author saying, and we spoke to the person, and then this is what happened, and then they go to a clip of an actual interview. The summary by the author is not admissible. It can't be used sensitively. It can't be used to impeach Ms. Reed should she testify. It is hearsay. It's inadmissible. And so these summaries have a genesis somewhere. There's a reason why the reporter is asking certain questions, or more importantly, the author is summarizing testimony, oftentimes inconsistent with other versions. And so
that's what they do in those things, right? That's what they do.
that means that there is footage from which the author has gleaned this information. There's either footage or there's a conversation with Ms. Reed. And so those are statements.
Right. Well, we know there's footage.
Similar to Ms. Voss interviewing here. Those are statements of a defendant, which are substantive evidence for their full value. And so that footage we're entitled to see. There's nothing that should protect it. We should have the opportunity to review all the statements and also put the ones in context that were broadcast to the nation.
So this is kind of similar in terms of like the redacted thing from the earlier, where in other words, the similarity here. Okay. So with the redactions were made, right, to suit, what the defense, they got to make those choices, what they did want in and what they didn't want, blah. This is similar in the sense that there's a lot of things missing, but this would have been the producers who made those decisions, right? So, we see this all the time with interviews, right? Where they probably interviewed, who knows how long they would have interviewed her for, right? It could have been an hour, 2 hours, 3 hours, right? But then the clips, because I think we've all seen them, right? It's like I don't even know. It's like a couple minutes, right? And it's like, yeah, the person, he's exactly what he said, the author, like summarizes it and then they cut to like a short little clip and then it goes back to more summary and then a short little clip. So he's right in that there's probably hours of footage that was taken from that NBC, has.
And that's the substance of why we want it. I'll have to take a moment to look at the response.
Okay. Mr. Albano, we'll give him a couple of minutes just to read it.
Okay.
F5, it's on page 3. The pages aren't numbered. Why don't you have a seat and read it?
Okay. Sit down and read it. There's Karen's dad. Is that Karen's mom beside him? I mean, I guess it is.
Subpoena an out-of-state witness. We're trying to subpoena materials from a company, and although the company has a principal place of business in another state, by having a registered agent, we believe that gives us jurisdiction. I can understand the company.
So this is the same thing we were just discussing about the whole problem with the out-of-state. Let me back it up so we can hear the beginning of this. Okay, let's see.
Your Honor, our position is we disagree with that proposition. We are not trying to subpoena an out-of-state witness. We're trying to subpoena materials from a company, and although the company has a principal place of business in another state, by having a registered agent, we believe that gives us jurisdiction. I can understand the company would like to remove this.
It's interesting because it's a different. With all the other interviews, right? You've got Gretchen Voss, you've got the ones with the parents. With every other interview, right? Again, unnecessarily, he's saying, we're going to call the person who was there. We're going to call them to the stand, right? And now that it doesn't suit him, right? Him, the Commonwealth, right? Because it would be an out-of-state witness. He's like, we're not going to call the out-of-state witness. We just want the statements.
New York, there is a reporter's privilege in New York that is profound. It is not so in Massachusetts. In Massachusetts, there is none. And so I see why it is the company's preference for us to go to New York, to use New York law, but I don't believe that's the case. I believe as a registered agent that we have an entitlement to subpoena them here and we follow Massachusetts law.
I thought you said there wasn't an agent
cases in the memorandum that I'm not aware of. I think it would be prudent for me to research and shepardize, and because I think I have an obligation to do that. I would ask you to allow me to have a day to provide a brief supplement. It's not to re-argue the case or the merits of the case, but if there is adverse case law, I want to recognize and acknowledge it.
I'll give you that opportunity, but I will hear from Mr. Albano today.
Of course.
So for anyone who doesn't know what shepardizing is, like, what the heck? We don't hear that term used very often, actually, in hearings or in trials. What shepardizing means is that when you're, a party, in any case, it doesn't matter if it's civil, criminal, whatever the case may be, whenever there's case law that's provided, Shepardizing means you go back and you actually go to that citation. That's why case law has to be, the citation is very specific. And, you know, the point is it allows the person who's reading the pleading, the motion, whatever the case would be, it allows them to go and pull that case up. Because what you'll have is you'll have people referencing a case or pulling out one particular, you know, sentence or whatever the case is. And then they're citing the case. But the thing is that sometimes there's errors, right? Like they could actually have something misquoted, or it could be, oh, what was it? There was an example recently. I think it might have been something related to P. Diddy, where I think it was, maybe, I don't know. There was an example recently though, where again, I think it was P. Diddy's defense attorneys, like they cited a case, you know, they cited case law, and literally it wasn't at all like, it wasn't at all what they said. Like in other words, it potentially could be sanctionable because it seemed like they were actually intentionally trying to mislead the court. And like and also making an assumption that no one's going to shepardize it, right? Because you could just chuck a case on there, right? And then say what, like, you know what I mean? So it's double checking that the other side is being, you know, honest and accurately citing the cases, but also it can also be because sometimes things are taken out of context. So they might put, you know, include a fraction of a sentence or a couple words of sentence, right? But leave out an important part right before it where it says, but this thing isn't true. And then they state the thing, right? So you have to, that's why you have to shepardize it for a number of reasons. You're validating the citation, right? But you're also making sure that it, that whichever party is using the citation, whatever they are indicating is from the case, that's accurate, right? That actually is what they are indicating it to be. That doesn't surprise me at all. Oh God.
So our position is, although they would like us to go to New York, we can submit it in Massachusetts to the registered agent, and that entitles us to the material. So that's the way we've done it.
Okay.
Thank you.
All right, Mr. Albino.
Oh, look, there's a turtle boy, right? Well, hold on. They're in the white jacket, white coat.
Okay.
Thank you.
All right, Mr. Albino.
Thank you, Your Honor. The two cases I cited, just to be clear, they address the Uniform Act, which Your Honor dealt with last year. They don't address the specific issue that Commonwealth has raised, which is, okay, you have a registered agent, we serve the registered agent, does that trump the Uniform Act? I have to say, I did not find a case that dealt directly or even indirectly with that. But here's why I believe this.
So in other words, he's saying he didn't find a case that was on point, right? Essentially. So he found case law that was the closest thing to it.
For this issue does not override the Uniform Act. First of all, we're dealing with a statute. Statute talks about a witness in another state. There's no dispute that ABC is a foreign corporation with a principal place of business in New York. Now, the analogous areas I thought of was, okay, let's say someone wanted to sue ABC in this court. Yes, they could serve them through their registered agent, but that wouldn't change the domicile or citizenship of ABC. If there were a diverse plaintiff and a diverse defendant, it would still be removable. It doesn't make them residents of Massachusetts, or for example, subject to taxes in Massachusetts. It's simply a way to make service a process, but the plain language of the Uniform Act and the policy underlying it is not overridden by service. The two cases that I did cite, one is the grand jury case out of, I think it started in Rhode Island, SJC case. And that just generally explains how this Uniform Act works. You go to the Superior Court here, you get an order, you travel to New York, and New York decides whether the subpoena will issue. The second case, which I think was in re contempt or something like that, was the SJC saying, by the way, the receiving court, and in that case, Massachusetts was the receiving court, we don't just rubber stamp these if there's a privilege issue in our state. And so that's what tells us that if this court issues us an order under the Uniform Act, Commonwealth travels to New York, and the New York court then decides, does it enforce it, or does the privilege that exists in New York, is that privilege dispositive? And that's what we say is the right answer here, that, yeah, they have a point, they can make service, but it doesn't override the statutory requirements of the Uniform Act. And as to the other, I think things are pretty much under control with the other motions. WBTS, which is NBC 10, has previously published those promotion ads for the show, and they say, well, no, they've already been out. Fine, we'll get you copies, and that's what I've been told by the client as well. WFXT, which unlike ABC is here, does have some raw footage. The station's position is that if Your Honor decides under the Rule 17 standard that yes, this footage is relevant enough to come within the Rule 17 scope, then WFXT will produce that information. I do expect it will already be published before it's published.
What is going on with this camera person? Oh my God.
Won't be
having like a seat
anymore, so there'll probably be
What's
a
happening?
position where they're simply
I hope
turning
they're
over,
okay.
Published information,
Okay.
not unpublished information. But I do think that, so I think WBTS and WFXT are effectively resolved.
Okay. Do you want to respond, Mr. Brennan? Thank you, Mr. Albano.
I'd just like to give one example that I'm sure you've thought of, and we see it often in tort law. If U-Haul is a foreign company, I don't know where it's located, but if the principal place of business is in Texas, and there's an accident here in Massachusetts, and I'm requesting as part of my litigation corporate materials, I do not have to follow the Uniform Act to go to Texas or litigate in Texas under Texas law, because the company operates also in Massachusetts, as does ABC. I can sue in Massachusetts, and that company, this registered agent, is obligated to get those materials for me. Otherwise, a company could simply hide in whatever state is most beneficial to them, make it impossible to litigate or obtain materials, and there would be subterfuge throughout the entire process. We have jurisdiction here because they operate here, because they have a registered agent here. It does not matter where their corporate or their headquarters is. Thank you.
All right, any follow-up, Mr. Albano? Sure.
My first point is that we're dealing with a statute here. The statute says this is how it works when you have an out-of-state witness in a criminal case.
Yeah.
So that's different than civil discovery.
Yeah.
The second thing I'd say is ABC has a registered agent here, but WCVB is owned and operated by Hearst Corporation. Hearst Corporation is totally separate from ABC. That's why neither of them could produce the documents in this case. So I just want to be clear that the presence of an ABC affiliate here, owned by an entirely separate company, Hearst, does not mean that ABC is here in Massachusetts. They're a foreign company that has an agent for service process. They don't have offices and the like here in Massachusetts. Are they doing business here in the sense of transmitting ABC news programs through affiliates? I don't argue that. What I'm arguing is there's not the service, the fact that they're subject to service does not override the requirements of the statute.
Is there a distinction between obtaining records and obtaining a person's presence to testify?
The SJC has said in the jury case, the first case I cited, that the same procedures apply to documents as for witnesses.
All right, thank you. So those are all the Rule 17 motions we have.
All right.
Missing anything? Those are all the Rule 17 motions. All right, so we have some housekeeping matters that I just want
Now I think when we're getting to hear about Morrissey.
I still have the motion to continue under advisement. I need to see.
What is wrong with her? Seriously. Really? Really? Are you going to tell them the day before? What is it supposed to be? January something. Let me see. Dude, I cannot with her. Let me look it up. I think it's the end of January. Let's see. Let me look it up. 2025. I can't believe it's almost 2025. January 27th, 2025. Is she going to like tell them on January 26th, hey guys, I guess I can't procrastinate any longer. Like, here's my decision. either restart trial tomorrow or you get your continue. I mean, this is just crazy.
How we progress for that. The Commonwealth's notice regarding the testing of the telematics system, where do we stand with that? I know you had said you told them that Thanksgiving rather than Christmas to highlight big holidays, but where are we?
I did, and if I could have done it, had it done quicker, I would have got somebody else. I have spoken to my expert numerous times. He has coordinated with the defense expert. They are heading to Texas on December 2nd.
Okay.
On December 2nd, they're going to test all of the chips, and there's an SD card that we expect has information on it. And then they're both scheduled to travel back to Massachusetts for December 5th.
Okay.
And they're going to do what's called a chip on, where they take the chips, the SD card, they reapply it to the boards, they put it back in the modules, and they put it in the actual car because there's different software which will give it even more fulsome reading. And so after the December 5th event is done, I've asked my expert if I could have all results within a week. I have an uncertain response, promised to do his best, which really doesn't give a lot of meaning, but my hope is within 7 to 10 days.
Okay, thank you. And I don't know, Ms. Little or Mr. Jackson, if you have the answer to this, the transcripts of the sidebar conferences. Ms. Little, do you have any scheduling idea on when those will be available?
Yes, Your Honor, I do believe that Mr. Jackson had spoken with the court reporter and emailed the clerk's office with an update. It's going to be a little bit longer than initially expected. One of the reporters had to go to a family emergency and needed some additional time. And so I believe, and I'll have Mr. Jackson.
Oh, dear.
If I'm wrong, but I believe she needed until about 6 weeks to get the sidebar conference.
6 weeks
The
from
sidebar.
the November 13th date?
6 weeks from about a week after the November 13th date.
Wow.
Thank you, Your Honor.
Wow.
All right. Mr. Jackson, did you want to speak?
Your Honor, Ms. Little addressed the board's specific questions about the transcripts, and that's as accurate a bit of information as I have, so I'll submit on that.
All right, thank you. All right, that is it for today. The Commonwealth is going
It's not
to
it.
file
It's not it. Don't worry.
a response to the discovery of communications in possession, custody, and control of the Commonwealth by 11/27, right?
Yes. Your Honor, I provided the defense this morning with a response to their motion. We'll
Okay.
file it with the court. It is a request that they made that is very labor and time consuming, but a very important task that I've been involved with. I expended many, many hours, and I need many more. We do have, or I have produced, or I have a production that I'd like to produce to the defense. I've shown them a protective order this morning to see if they were agreeable. I do not want to speak for them. If there is a protective order, I can turn over the first production that I produced, and there is more to come.
All right, any objection to the protective order? I have not seen this document, obviously, nor the proposed order.
Right, there are a couple of issues related to this.
Here we
motion,
go.
the protective order that I'd like to address with the court that I've briefly discussed with Mrs. Brennan.
I haven't read this yet, so I won't know what you're talking about. Mr. Mayor.
So I believe you have read our motion, right? The motion that
I
we-
read your motion. I have.
Right, so it's just in relation to the motion. Judge.
All right.
So, Your Honor, generally speaking, we do not have an objection to a protective order as long as it is issued without prejudice, which I believe Mr. Brennan is in agreement with.
All right, is there one here? Was there a proposed protective order?
I have it right here, Your Honor. Mr. Brennan provided this to us this morning.
So I have not reviewed that, Your Honor, but I'm asking that the contents be allowed to be shared with the entire defense team, including our attorneys, our interns, and our client. I don't believe Mr. Brennan has an objection to that, but that would be our request with regard to the protective order, with the understanding that we could come back before the court and revisit that if we deem it appropriate.
Is there any objection to the sharing with the
There's no
defense team?
objection to the parties they would like to share, and I understand it's no prejudice.
Okay.
Yes, and with regard to the motion itself, Your Honor, I had come prepared with an argument for the allowance of the motion. Given Mr. Brennan's, the work that he's done in terms of trying to gather this material and get it to us along with the protective order, I assume that there's no general objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion. But I would raise an issue for the court, actually two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phone.
Here it is.
One work cell phone and one personal cell phone. Obviously, the personal cell phone becomes relevant because he used the personal email address to make an ex parte communication with the court. One concern that we have is that we were told this morning that with regard to Mr. Morrissey's text messages, not emails, but text messages, apparently they're somehow remarkably set to auto delete after 30 days. That obviously raises some questions for us may be the subject of a future motion. But more immediately, the concern is every day that passes, we're losing text messages from 30 days prior. So, through today, I
Can they
believe.
be preserved, Mr. Brennan?
I've been preserving them since I started the task last week. I'll continue to preserve them.
All right, so that.
Yes, that deals with that issue. So the only remaining issue, Your Honor, is with regard to the searches that Mr. Brennan conducted himself. He had searched for all emails sent from Michael Morrissey's iCloud personal email to any emails that had a JUD in the suffix of the email address.
Okay. The significance of that is?
The significance is that would supposedly capture any ex parte communications with members of the judiciary or the clerk's office, and I appreciate that effort. However, we think we assert that it's insufficient. We believe that searches should be done of his iCloud email for the name Reed, spelled R-E-A-D correctly, or Reed R-E-E-D, which is how Mr. Morrissey typed it in his ex parte communication.
Oh boy, he spelled it
wrong. I don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name, but we believe there should be a search for both of those spellings. And in addition, we also believe there should be a search of his email address, the personal email address, for the names of the relevant witnesses, and we can give the court a list, for the names of all judges who have sat on this case.
Oh boy.
In terms of, is there an attempt to communicate with a judge on some type of personal email account, like he used a personal email account? And then also we believe there should be a search for any clerk's office employees for the same reason, both at Stoughton District Court where this case originated and this court as well. We have obviously reason not to trust Mr. Morrissey in light of his actions using this personal email account to make an ex parte communication. And we'd ask that a more thorough search be done for these types of communications.
All right, so why don't you continue to talk with Mr. Brennan and we can have a hearing on this motion if there's anything that you still need on December 12th when we're back here for the Daubert hearing.
That's fair enough. Thank you.
Does that make sense, Mr. Brennan?
It does. I've taken extensive steps to do this myself to accommodate the defense in the most broadest fashion. And I'm going to do that. If they want to discuss how I can accommodate them, I'll do my best.
All right. So we will see everyone December 12th. So when do you expect to get me any written material you want me to have prior to the Daubert hearing?
Yeah.
Yes.
Your Honor, we grabbed the landing and hearing motion. I need to review it. I'd like to get it to you by the end of the week.
That's great. I expect to be here by at the end of the week, so that's great.
Thank you.
And your response by next week, Mr. Yannetti? Ms. Little?
Yes, if we could have it at least a week, Your Honor.
Okay, so I'll give you 10 days,
Thank you.
as long as that gets me before the 12th.
No problem. Yes, Your Honor.
Yeah, if I can get it, as soon as you can get it. All right. Anything else? Yes.
I'm sorry to interrupt.
That's okay.
May I
Oh,
inquire
something else.
if the executive order is going to be signed by the
Are you going to sign the protective order, Mr. Yannetti?
I expect I will, without prejudice.
I have material. I'll just wait. to make a
Okay.
decision.
All right, so if you sign it, then I'll endorse it, Mr. Yannetti. You had it, right? Ms. Little gave it to us just now?
I believe we received our copies in court.
Yes.
All right, so this is the one that needs to be signed and I'll endorse it. Do you want to take a look at it?
Yes. All set.
Mr. Brennan, I know you have an electronic signature. I'd like you to sign this as well since you're here.
Yes, Your Honor.
You sign that and I will endorse it.
You're signing it.
All right, thank you, and I appreciate counsel and the third-party record holders coming in today.
12:9 a.m. All rise for the pledge, please.
All right. So we learned a lot. I would say maybe not as much as the last hearing, but one thing that was interesting, well, there were a lot of things, but in terms of with Morrissey, right? So we heard that he has somehow has a function on his phone that auto deletes text messages after 30 days. Okay. And then also that apparently he has used the spelling R-E-E-D to spell Karen's last name. And, whether it's on purpose or whether it's a typo, I mean, I don't know. I think that answer is pretty clear because how the heck would you, anyway. So the protective order is them seeking to keep him from deleting further further communications, text messages, emails, things like that. But also what else we heard was, again, for me, a really new tactic coming in from Hank Brennan, in terms of how he, in contrast to the last hearing, and seems to really be after these statements, like hardcore, that Karen made to her parents, that Karen made to the media, that her parents made to the media. Because he was a very different attorney, in my opinion, today, arguing in this hearing. So, as per usual, Judge Bev is taking everything under advisement. So we don't really have any more answers from her as to when is the trial going to be? Are we sticking with January 27th, or is it going to be moved to April Fool's Day? And what about all this discovery, right? So, that remains to be seen. It's just crazy that, I don't understand how, if she's actually trying to maintain this upcoming trial date of January 27th, it's bad enough not to rule on that issue in and of itself, but like to not even rule on these big discovery issues. It's like, if you're expecting everyone to go to trial on January 27th, it is the end of November. And you're not even going to rule on the other things, let alone if the continuance is going to be granted. It's bizarre. Even for her, it's just still surprising, because it's like, I don't know, man. What is her, this is a rhetorical question. Why? Just why? Why is it so bad for her? It doesn't behoove her to have this trial on January 27th versus April 1st. They already made it clear that the trial will be shorter, more streamlined. Anyway, there's no law. There actually is no actual argument that one could make to say it should be had on January 27th. There's literally no argument to me being, apart from her being like, I said so, because I said so, that type of thing. So yeah. Yeah, and again, they're still working on getting all the transcripts of the sidebars done. They're still working on getting the telemetry right, because their expert, was busy and whatnot. So I think the next hearing is scheduled for December 12th, but I'll keep my eye out. At this point, I don't even know. Is Judge Bev going to rule on any of this stuff? I don't know. But I'll keep my eye out just in case. But nonetheless, at the very least, we'll be having that hearing now on December 12th. That's going to be really interesting. That's going to be the Daubert hearing for, oh my God, I'm blanking on her name. The defense expert, the dog bite. Oh my God. Dr. Oh my God, what is it? I can't remember her name. I'll think of it as soon as I'm not trying to think of it, more than likely. But I almost had it. Anyway, but that awesome lady from California, that's what the Daubert hearing is about, which again is interesting, because it sounds like the defense really wants to bring in the nature of those injuries to the arm. And they're the reason for this is because it sounds like they really want her to be able to get into the dog bite. And she wasn't allowed to do that in the first trial. So that gives us a little hint as to maybe what the defense's strategy is. It'll be interesting to see too what's going to happen with the McAlberts, right? Because it sounds like the Commonwealth isn't going to call them, but the defense could call them. Will they? Or are they going to be like, what, maybe that wasn't the smartest thing? Because, there was a lot of talk, we talked about it, about, were they focusing so much on the third party thing? And in this case, it was really clear. This case is only reasonable doubt, And so it's like, even though you had so many things that really were in support of the third party and there was so much shadiness, there's so many other things, it's like, it's distracting from what the jury is supposed to really look at that reasonable doubt, right? And in any case, I think it almost in a way weakened, if you will, the strength of the weakness of the state's case. In other words, those closing arguments, man, had Mr. Jackson spent more time on just the state hasn't proved anything and the state's case is a mess, basically, right? They haven't met their burden, the reasonable doubt and all that. That's what the jury, when they go back to those jury instructions, that's what they're reading. They're not reading things about a third party, blah. You know what I mean? So you want to use those words that are going to be repeated in the jury instructions so that when they get back there, they're like remembering what you said. And anyway, there was a lot of talk about it. We've talked about it, but just reminiscing about, are they thinking, well, maybe we need to, but having said that, the dog bite thing is still really part of the third party strategy. So are they not changing that? I find it really interesting because I think that the only thing that one could say, if it's like, how did this end in a mistrial? Like the only thing you could say, assuming the jury was properly voir dired, is that the only fault you could have is like the state's case couldn't have been any worse, right? So the only fault you could have in terms of what could the defense do differently this time around, the only thing that anybody can say, including myself, is maybe they just went too hard on that third party and not hard enough on the mess that was the state's case. Yeah, the thing is that it's a disaster, right? Because the problem is, in terms of like, never mind the McAlberts, but even like Michael Proctor, he was the lead like investigator in this case, the lead, and the others too. That you had Guarino, you had Tully, all of them, like, as y'all know, I'm sure, like Proctor's in just a ton of hot water, but the others are as well. And that was one of the questions that has arisen is like, well, how are they even going to present a case? Because they have to testify. They are the key witnesses. Like you don't have, so that's one of the reasons why a lot of people didn't think the state, including myself, would retry this, because you can't get in that evidence without putting these people on the stand. So either you put them on the stand, and imagine how that's going to go, worse than the first time, right? Because again, now they're all subject to investigations, they've been fired or in the process of being fired. There's so much more that's come out. And also their involvement. Now, I don't know that they'd be able to get into this, right? But these guys, same folks, these same law enforcement officers are all tied up in that that other case. Oh my God, I'm blanking on the name. The other one out of Canton, with that poor girl who was killed and the cop staged it as a suicide. What is her name? Hold on. Let me see. Sandra Birchmore, that's the one. Yeah, they're all involved in that as well. And they like what seems like is what, from what we can tell, is that they were responsible for like turning a blind eye as when all these text messages from the law enforcement officer who what was his name? And Morrissey's all up in that as well. It's like all the same people. Let me see here. I'm just looking for the name of the cop. Farwell. Timothy Farwell. So the text messages that between him and her, whatever. Anyway, they just turned a blind eye to it, if and maybe even potentially helped him cover up. There's a whole lot, but basically it's a mess. Whether they can get into that or not, putting them on the stand. But again, they can't. They have to, because otherwise they don't have a case. Like they can't get in. They can't get in any of the if you want to call it evidence, right? Be it how they collected the things from the scene, and be it how they got into the GPS and the cell phones. And, I honestly can't even remember what all they did, because it was such a mess, and it was all, I guess Tully talked about how they, he was like overseeing the search, but then Guarino was the one who did the phones and the car, but he messed that up. And the other thing is, if the Commonwealth doesn't call them, the defense will. So the Commonwealth has to call them. I just don't know how the heck they're going to handle this, because it's, it's going to be a disaster. So, and the other thing is too, by the time this trial happens, now maybe this is why, I just now dawned on me, maybe this is why Judge Bev hasn't said she's going to continue this trial yet. Because the thing is that these investigations Even just going through like the union and stuff like that for them to be officially fired, that stuff all takes time. They have like hearings that they get to have or whatever before they can like officially be fired. It's like right now, like Proctor is on like unpaid vacation or whatever. And I think the others are on paid vacation, which is just insane. But anyway, I wonder if there's a timeline to that to where by April decisions will have been made. Because what I was thinking is by the time the trial happens, whenever it is, whatever status they're at is going to be worse than it is now for those guys. And some decisions will be made, or at least will be further in the process, and then it's just worse for the Commonwealth. And I wonder if that's the only thing that could be keeping her from continuing this to April 1st, because January 27th is sooner, and maybe she has an idea as to how these are. I would imagine she does. So that's another interesting thought there to that. So anyway, so y'all, thanks for watching. And tomorrow we have the next episode for Casey Anthony, and I'll be doing another Kohberger update as well, probably on Thursday on Thanksgiving, because I have a bunch of stuff I want to go over for that, even if there's not any new court filings, which there very well may be. So, but that's it for this one. Another hearing down, and love y'all. Thanks for being a squirrel, and see you guys next time. And if I can find the outro video, here it is. See y'all later.